Welcome back to this course on copyright and related rights law. In the previous session, we had discussed Section 51 and its components. We had seen what is it that the Indian Copyright Act considers to be infringement of copyright in a work. In today's discussion, we are going to see whether Section 51 is to be applied the way it is, or is there some kind of an analysis that is conducted by courts when an infringement action comes before it. Consider the question whether copyright infringement is only literal infringement, or in other words, is only verbatim copying amounting to infringement. Now, when we looked at what is it that copyright is attaching to, we had understood that copyright doesn't apply to an idea, copyright applies to the expression. Is it not then that infringement of an expression should be the replication of that expression, and just that? Because if anything else, then we are looking to bring in a subjective analysis in this infringement consideration. In other words, it is no longer a literal copy. There are non-literal elements that must be considered for infringement to be upheld. Let us recall an earlier discussion that we had on fair use. Recall Section 50, recall Session 51. These are the two sets of lyrics that we had discussed. See these lyrics. One set reads, "Pretty woman, stop a while, pretty woman, talk a while, pretty woman, give your smile to me." And the other set reads, "Bald-headed woman, girl, your hair won't grow. Bald-headed woman, you got a teeny-weeny afro." Now, in terms of a replication, there isn't any. There is no literal copying. But in terms of whether there was infringement or the possibility of infringement, to which there was a defense of fair use which was being applied, there was no debate. In Campbell versus Acuff Rose, it was a given fact that if not for the exception of fair use, this was infringement. Now ask yourself, is there literal infringement here? You will all be saying that there is no literal infringement. There is no verbatim copy. The expressions are different. But if indeed expressions are different, then how would adaptations enjoy their copyright protection? Let us recall Session 45, in which we discussed adaptations. We had seen that Section 2 Clause A, which defines adaptations in the Indian Copyright Act, is saying adaptation means, in relation to a dramatic work, the conversion of the work into a non-dramatic work. Would the expression not change if the subject matter is being changed? Thus, to limit copyright to only literal copying and such protection would be to in a way say that adaptations which are not literal copying do not enjoy copyright protection. On that note, we are going to consider one of the most important cases that have arisen under copyright law in India. This particular case is R.G. Anand versus Delux Films, decided by the Indian Supreme Court. Because we will be looking at this case in a lot of detail, we will be focusing on facts. These facts will help us appreciate the pronouncement of the Indian Supreme Court better. R.G. Anand, the dramatist, had written a play called Hum Hindustani in 1953. It was enacted for the first time in the following year in 1954. Such was the popularity that this play received that R.G. Anand considered a film that could be made on this play. The same year, later, R.G. Anand was approached by the defendant, who claimed that he had received the synopsis of the play from a common friend. The defendant seemed to be motivated to make a film on the play written by R.G. Anand. For this purpose, a request was made to R.G. Anand to supply a copy of the play to the defendant. R.G. Anand in turn had said that the play was going to be enacted and the defendant should come and watch the play and then decide for themselves whether there was a potential for the conversion of this play into a film. It was the next year, in 1955, that the defendant met R.G. Anand in Delhi. It is the contention of R.G. Anand that in this meeting between the defendant and the dramatist, R.G. Anand read out the play and explored the possibility of the play being converted into a film. At this time, no commitment was made by the defendant, who simply said that they will inform R.G. Anand of their decision once they return to Bombay. It was later in the same year, in 1955, that the defendant announced the production of a film called New Delhi. One of the artists who had worked on the play, Mr. Thapa, who was present incidentally in Bombay at that time, had seen this production and informed R.G. Anand that the film was in fact based on the play Hum Hindustani. Upon this information, R.G. Anand had brought to the notice of the producer his serious concern that the film was an adaptation of the play. But the defendant rejected this consideration by stating that the story treatment, dramatic construction, characters, they were all quite different and bore not the remotest connection or resemblance with the play written by R.G. Anand. The picture was eventually released in Delhi in 1956, and at that time the newspapers commented that the picture bore resemblance to the play. R.G. Anand himself went and watched this picture and was of the opinion that it was based on his play. In fact, according to R.G. Anand, it was entirely based upon the said play, and he was convinced that this picture was dishonestly imitated and therefore resulted in a violation of copyright that he had in the play. The defendants denied that there was such a connection between the film and the play, and they stated that there could be no copyright in the subject of provincialism, which could be used or adopted by anybody in his own way. What is provincialism? Provincialism means to concern for one's own area or region at the expense of national or supranational unity. Provincialism is the subject that underlies both the play as well as the film. This thematic consideration is something that the defendants are contesting is different. It's a different expression. There could be similarities, but there are also dissimilarities. In fact, this contention would be reasoned out in saying that the dissimilarities are much more than the similarities. In fact, the similarities are such that they are very common in nature. Do these questions of similarity and dissimilarity within an expression have any role to play in the determination of whether an expression is an infringement of another? This is what the court is looking to answer through this particular case. The court is saying, first, that the play is a dramatic work. It is then saying, in a simple answer to the question that we were looking to answer, which was whether copyright infringement is restricted to literal copying or not, the court has provided an answer that no, it is not restricted so. But the Supreme Court engaged in an exercise of expanding this simple answer such that its complex facets can be understood better. Let us then look at two extracts particularly which I have taken for the purpose of explaining the Supreme Court's exercise from this particular judgment. One extract that the court refers to is an extract from a book on copyright by Coppinger, in which the learned author had stated, various definitions of copy have been suggested, but it is submitted that the true view of the matter is that where the court is satisfied that a defendant has, in producing the alleged infringement, made a substantial use of those features of the plaintiff's work in which copyright subsists, an infringement will be held to have been committed if he has made such use, he has exercised unlawfully the sole right which is conferred upon the plaintiff. What does this mean? Does this mean that when we consider an expression, we must divide the features of such expression into two categories? One, features that are copyrightable and features that are non-copyrightable? If indeed that is how we are supposed to categorize an expression, then what this extract suggests is that from the features that we have found within the set that is copyrightable in an expression, if substantial use has been done by a user, then such a use would be considered as infringing. What you would understand from this is naturally that the more features that you can add in this category of protectable elements, there is a much higher chance of copyright infringement. The other extract that is considered by the Indian Supreme Court is by this author, Horace Ball, who states, in an action for the alleged infringement of the copyright of a play by a motion picture, wherein it appeared that both authors had used life in a boys' reform school as a background, but the only similarity between the two productions consisted to a few incidents and points in dialogue, such as one would expect to find in stories set against the same background. There was no infringement of copyright. Can we not connect the first extract with this? In this particular extract, where there is a discussion of a specific case, can we not say that the features that are present in an expression, if they are commonplace, if they cannot be considered as features on which copyright can subsist, then the use of those features by another individual would not amount to infringement. The Supreme Court, on the consideration of several cases and authorities, provides a summary of certain propositions. Let us look at these one by one. The first proposition is that there can be no copyright in an idea, subject matter, themes, plots, or historical or legendary facts, and violation of the copyright in such cases is confined to the form, manner, and arrangement and expression of the idea by the author of the copyright work. This is one of the basic tenets that we have discussed in our earlier classes on copyright law. Consider the example of a news item. The item that the news is presenting is commonplace. It's a fact, and facts cannot be copyrighted. What this proposition then states is that the expression, particularly that specific form, that is what will be considered for the purpose of copyright infringement. The second proposition is that where the same idea is being developed in a different manner, it is manifest that the source being common, similarities are bound to occur. In such a case, the courts should determine whether or not the similarities are on fundamental or substantial aspects of the mode of expression adopted in the copyrighted work. If the defendant's work is nothing but a literal imitation of the copyrighted work with some variations here and there, it would amount to violation of the copyright. In other words, in order to be actionable, the copy must be a substantial and material one, which at once leads to the conclusion that the defendant is guilty of an act of piracy. Let us consider that two authors have worked on the same idea but have emerged with different expressions. Even though the expressions on the face of it seem different because of the language that is employed, the sequence of that expression and the features which are connecting those expressions together, where there is an imitation of the original expression, then it could be said that even though there is no verbatim copying, when we read two expressions, it could emerge that the other is considered to be a copy of the first. Bear in mind that two individuals who have independently done this without having access to each other's work, these two independent creations would be original. But we are considering a situation such as the one in this case, where two people have worked on an idea stating that they have made different expressions, but they have had access to the original work. Let us consider the third proposition. This says, one of the surest and the safest tests to determine whether or not there has been a violation of copyright is to see the reader, spectator, or the viewer, after having read or seen both the works, is clearly of the opinion and gets an unmistakable impression that the subsequent work appears to be a copy of the original. Does it not happen with us as well as ordinary readers? When we have read a piece of work followed by another piece of work, and even though they are literally different, we are able to say that the second work is an imitation of the first. This is what the court is saying. The court is suggesting that the proposition that emerges from the authorities that the court has referred, which are case laws and commentaries, they are suggesting that it is possible for such an impression to be left on the minds of the reader or the mind of the spectator or the viewer that there has been copying. The fourth proposition is where the theme is the same but is presented and treated differently so that the subsequent work becomes a completely new work. No question of violation of copyright arises. Let us understand that there can be dissimilarities of such a nature that the expression is serving a new meaning. We can connect this understanding to something that we had discussed earlier under fair use. The transformative nature of a particular expression. Even if a work, along with a consideration to another work, is, as this proposition states, on the same theme, they could be on completely different pedestals in terms of the meaning that they are providing to the reader. The fifth proposition is where, however, apart from the similarities appearing in the two works, there are also material and broad dissimilarities which negative the intention to copy. The original and the coincidences appearing in the two works are clearly incidental. No infringement of the copyright comes into existence. The sixth proposition is that as a violation of copyright amounts to an act of piracy, it must be proved by clear and cogent evidence after applying the various tests laid down by the case law. An act of piracy is a serious consideration in law in which it is considered as an offense. Every act of infringement of copyright, which is by knowledge, is an offense as well, and therefore any such action of infringement must be proved with cogent evidence. And 7, where however the question is of the violation of the copyright of stage play by a film producer or a director, the task of the plaintiff becomes more difficult to prove piracy. It is manifest that unlike a stage play, a film has a much broader perspective, a wider field, and a bigger background, where the defendants can, by introducing a variety of incidents, give a color and complexion different from the manner in which the copyrighted work has expressed the idea. Proposition 7 then in effect synthesizes the earlier propositions in applying it to a specific circumstance where there is the possibility of an infringement, wherein a play has been converted to a film. Because the film is on a broader canvas, it can present a very different purpose and meaning to what could be similar features. How then does this understanding and these propositions play themselves out in terms of the particular facts of this case? We will then take up the latter part of the discussion of R.G. Anand in the next discussion. Thank you for joining me. See you all in the next session. Thank you.